and the officer made contact with the defendant asleep in the living room. The defendant woke up in
Whoa, no means no. Doesn't mean it's the holidays, doesn't mean I have a birthday. A court order is a court order. Good morning, Mr. Villagas. Sir, you're charged with failure to give information upon striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, Judge. On December 28, 2024, the officer was dispatched to apartments in Harris County, Texas, in regard to a single vehicle accident that hit the mailbox of a residence. The officer observed the defendant's motor vehicle with heavy front end damage, but did not locate any driver or occupants inside the vehicle. During an inventory, the officer located the defendant's photo ID and Texas utility bill that came back to the defendant's name and address, approximately 1.4 miles from the accident. The registered owner of the mailbox came back to the defendant of the utility bill and his address. The officer went to the defendant's residence, noticed the garage door open and garage interior to the residence wide open. The officer made contact at the residence, one to make sure the motor vehicle was not stolen and one to make sure the owner of the vehicle was okay. The officer went inside the residence after knocking and announcing his presence several times under the community caretaking doctrine, and the officer made contact with the defendant asleep in the living room. The defendant woke up in
Whoa.
Yes, Judge. It was because they had
Whoa.
Yes, the vehicle was damaged and he wanted to make sure the driver was okay. So he announced himself and went into the residence because the door was wide open.
Wow.
And then it was after that he saw the defendant asleep in the living room, and the defendant woke up and immediately said the car accident, that he did not cause any injuries or any trouble, and that he was driving his motor vehicle 2 to 3 hours prior, and that he was on his way to drop it off at a mechanic when his vehicle was hit. The defendant called the insurance company, and the defendant walked home because no one arrived on scene, and the defendant was going to pick up his motor vehicle in the morning. And the officer made contact with the complainant, who stated she heard a loud bang and observed damages, approximately $1,025.
So, are you telling me that he did stay though?
No. What happened, Your Honor, is that he struck the mailbox at the apartment, and the defendant said that he called his insurance. No one came to the scene, so he walked home. And the officer, when he arrived, saw the empty.
Did he make an attempt to make a phone call at the scene to anyone?
All he said is that he called the insurance company. That's the only person that he had stated he called. And then after that, he walked home because no one arrived on scene. And then that's when the officer arrived and saw his empty vehicle damaged. And then he found a utility bill and the ID.
I have so many questions. Let's do this. I'm going to appoint you a lawyer, or you have a lawyer, right? Let's do this. I'm going to hold off on finding probable cause at the moment. Let me wait for your lawyer to get here. We'll revisit PC here momentarily. Just go ahead, take a seat for me if you don't mind in the jury box. Let's wait for your lawyer to get here, and then we'll go forward. Michael. Yeah, come on in.
Mr. Jill Villagas, Your Honor.
Did you look at PC?
I think we're prepared for argument.
Okay. Morgan, are you ready?
Yes, Judge. This is Villagas, correct?
Villagas, yeah. Go for it. Okay. Ball's in your court.
Your Honor, Mr. Villagas, when he climbed to the mailbox pole, he didn't stop. He got out of the car. There's no one to talk to. And so from there, he went to his residence, Your Honor. But, it's not a case where he didn't identify himself or anything.
This is the moment where the entire case starts to hinge on one key legal phrase: reasonable steps. The defense argues that knocking on someone's door at nearly 2 a.m. may not be practical or even safe, while the judge appears focused on whether the defendant made any meaningful effort to notify the property owner after damaging the mailbox. Notice how the discussion shifts away from the accident itself and toward the driver's obligations afterward. That's often where these cases are won or lost. What do you think? If you accidentally hit someone's mailbox in the middle of the night, would leaving a note be enough, or would you expect the driver to make direct contact with the homeowner?
And then we don't know what the restitution amount is going to be for the mailbox.
My concern was that according to the statute, right, it says that you're supposed to, I don't even know.
Take reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time? It was just the middle of the night.
$150 in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open it.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the...
Probably, Judge, but I would want to know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look through the peephole and I would see, and
I
then I would
guess
see a
there
crashed car.
are other measures I guess you could take theoretically.
Do something.
Right.
I guess leave.
Right.
Maybe leave a note on the door.
Okay, all right. Mr. Biagas, come up. I mean, reasonable measures, right? And I guess that would... Have you run his license, see if he has a valid Texas driver license? Mr.
An out-of-state Florida license that appears valid in our system.
Okay. Mr. Biagas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand? Okay. You've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Famine. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
I'm okay with your conditions, Judge. Just no driving without
Yeah,
insurance.
just
Law
be
violation.
careful out there, okay?
He does have insurance. Can you rip the CW and
Yes.
then we can settle it?
You did have insurance,
Yes.
hopefully.
Yes, sir.
Yeah, wonderful. Great. Okay. All right, man. Take care. Have fun. Can you file that? Do you mind those conditions? All right, Vic, you ready? Wow, really? Nice.
Your first day as well.
Hi.
Hi, Judge. Good morning. Permission to approach?
Yes, ma'am. How's it going?
Hi, Judge. Happy New Year.
New Year?
I'm here, Ms. Shaniqua Smith, Judge.
Okay.
I did court with an update on it. We have everything submitted for the DWI PTI program. However, Ms. Smith attempted to get the interlock device on her vehicle, but she has an electric vehicle, so she was told that it would not be able to get placed on her car. So Attorney Carter has been communicating with Beetle to try to figure out what we need to do then.
He's
And
no
we
longer
haven't
here, so
We haven't heard back from him, so that's why.
yeah, he's not with the office anymore.
Okay. Okay.
Alex, do you have any idea what they do with electric vehicles?
So we do have information that she was approved for the DWI program. And then they emailed a procedure to follow. So presumably if she still follows the procedure outlined in the email sent from Beetle prior to his departure, then
Well, the issue isn't necessarily the procedure. It's what do we do when we can't get the interlock device installed on the vehicle, which is part of the procedure based on her having an electric
Does she
car.
have another vehicle?
No, Judge. And I know she has to drive, so she can't do the portable because then she has to sign the affidavit, which would say she's sworn to not be able to drive.
so in that case, it would probably be best to reach out to Brenda Gomez or Bernadette Habe, who's in charge of right now the DWIs.
Hold on a second. Let's do that. And then your client has bond violations too. Do you know that?
No, Judge, that I did not know.
Shanika Smith, come up. I'm printing this out for you.
Judge.
Who is the other one? Gomez, and who is the other one? Alex?
Bernadette Habe. I can,
Oh, Bernadette, she's Miss Habe. She's the one in charge of everything, right?
yeah, she's the one overseeing.
I mean, if you want to go talk to her, but she's got bond violations. Yeah, you guys go figure out, but you've got bond violations, man. I don't know what we're gonna do now. Okay, please.
Thank you, I'll step aside. Thank you. Do I have permission to approach?
Yep.
Would you like me to ask Ms. Smith to come up again? Ms. Smith? And I spoke to Wolf and I didn't realize he had already had a conversation with her, Judge. And I will. I did speak to Wilden Carter, and he advised that he had spoken to Ms. Smith as well regarding the possibility of this being the result. He and I spoke to her again just a moment ago. We were out there on call, and at this time, Judge, Ms. Smith, that we were going to have her speak on her own behalf, Judge, because I think it's important for her to take ownership for what this report shows.
I don't care. I'm putting an ankle monitor on you now. If you ever test positive for alcohol again, I'm going to put you in jail. That's it. No means no. Doesn't mean it's the holidays. Doesn't mean I have a birthday. A court order is a court order. And when you don't follow court orders, there's only one place that we have you go. There's no tolerance anymore. And I don't care what you come up here and say, whether it's mouthwash, a tequila lollipop, hair dye. I don't care. And I don't care who you're with. A second violation. Do you understand? Today you will get an ankle monitor, and I'm going to tell you now, it is extremely finicky. So best beware of anything that you put in your body. Okay, no more. That's it. Okay. As far as the other, I don't know. What I would suggest is, email if you can now, Brenda Gomez, and see how we handle it, because I don't know. All I know is that this case is nearly 200 days old, and now we have violations, and I'm ready to put this thing to bed. I'm not going to hold it anymore.
Yes,
So,
understood.
I'll give you guys to the end of the week, figure out what we need to do.
Okay.
But you're walking a very, very thin line. Do you understand? All right. So, Felicia, if we can amend it to put it on today, please. Yes, ma'am. Okay. Thank you.
Judge, can I get contact information for who you said I need to speak with? I'm going to make sure I have the email.
Yeah, so
I can just take a quick
the person looking at it is going to be Bernadette Havey. So yeah, you just
Okay, I'll make it easier though.
yeah. And then the other person, do you have Brenda Gomez's contact information?
Just make sure I have it.
I don't know if you got this email before, because it has it on there.
Oh,
You can
okay.
make sure of it
Just so I
again.
can double check.
Yeah.
I'd rather do this
Good
now
idea.
than not have it later
Yeah,
if I
no
walk off.
problem. Yeah.
Thank
No
you.
problem.
Thank you, Judge.
Take care.
What a contrast between these two cases. In the first matter, the judge focused on whether probable cause existed and reminded the defendant about the importance of maintaining insurance and following legal requirements. In the second case, however, the court's attention shifted to compliance with bond conditions, and the judge made it crystal clear that repeated violations would not be tolerated. The message from the bench was simple. Court orders are not suggestions. They are mandatory. Whether it's reporting an accident, complying with a bond condition, or following a court-ordered program, accountability remains the central theme. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.